he succeeded in 3 different litigations. By this executive order, orders passed by my lord, this honorable court has been, my lord, reversed.
No, it's not a question of reversal. It is how they write.
Yes.
Because they think they are above all. Yes, what is this?
Lord, your lordship has asked
where is that lady?
She is on maternity leave, my lord. RDO is here.
என்ன இது? அவர்கிட்ட கொடுங்களேன் அத. உங்க டைப் செட் அவர்கிட்ட கொடுங்களேன் தயவு செஞ்சு. படிக்க தெரியல, ஆங்கிலம் படிப்பீங்கல்ல? கத்த மாட்டு சொல்லியா? படிப்பியா? நான் கத்துறேன்ல. ஆங்கிலம் படிக்க தெரியுமா தெரியாதா? தெரியும்ல? கொடுங்க 100வது பக்கத்து கொடுங்க. அதுல 81வது பக்கம் 81வது பக்கத்துல பாருங்க யார் யாரு வாதிகள்னு. இந்த வழக்கு ஐயா நான் சொல்றது கொஞ்சம் கேளுங்க. சர்ச் ஆஃப் சவுத் இந்தியா ட்ரஸ்ட் அசோசியேஷன்ங்கிறவங்க ஒரு வழக்கு போடுறாங்க. இந்த தாவா சொத்துக்கள் அவங்களுக்கு சொந்தமானதுன்னு 5 பேர் மேல முத்துராமலிங்கம், சேம்புக்குட்டி நாடார், அத்திலிங்கம், ராமலிங்கம், ரத்தினம்னு அவங்க இந்த சொத்து எங்களுதுன்னு சொல்றாங்க. ஹைகோர்ட் அதெல்லாம் 2வது அப்பீல்ல 100வது பக்கத்தை எடுங்க. அதாவது இந்த சர்ச் ஆஃப் சவுத் இந்தியா அசோசியேஷன் தான் வாதி, பிளைன்டிஃப். 100வது பக்கத்தை எடுங்க. It is to be pointed out, 19வது பேரா இருக்கா? It is to be pointed out that the plaintiffs have come forward with the case of title and possession, knowing fully well that they have no title. The plaintiffs come forward to allege that they have title to suit property. அப்படின்னா என்ன அர்த்தம்? அவங்களுக்கு உரிமை இல்லை என்று தெரிந்தும் உரிமை உள்ளது என்று கூறியிருக்கிறார்கள். அடுத்தது, finding that such a case cannot be maintained, they chose to abandon the same. அதையும் அப்படியே விட்டாங்க. There is no evidence, much less satisfactory nature, to support the case that the plaintiffs are in possession of the property. அவர்கள் சுவாதீனத்தில் இருக்கிறார்கள் பொய், தவறு. Even otherwise, as against the plaintiffs, defendants have better title in the sense that பட்டா has been granted in the name of the temple. கோயிலுக்கு பட்டா கொடுக்கப்பட்டிருக்கிறது. இப்ப உங்க RDO இருக்காங்களா அம்மா மகாலட்சுமி பிடெக், அவங்க என்ன சொல்றாங்க? எந்த கோர்ட்டும் இந்த சொத்து அவர்களுக்கு சொந்தம் என்று சொல்லவில்லை. சொல்லிருக்காங்களா? இப்ப படிச்சாருல வக்கீல், கேட்டீங்களா? அது சரியாது? சரியில்லை. என்ன செய்யலாம்? 10 மாசம் சம்பளம் கட்ட சொல்லிடலாமா? காஸ்டா? எங்களை திட்டுங்க, ஆனா எங்களை மீறி உங்களால ஒண்ணும் செய்ய முடியாது. வெளில போய் திட்டுங்க, என்னோட திட்டுவீங்க தெரியும்.
May you please speak?
Another thing, the government officials were not made as...
Whom are you appearing for?
Lords, I appear for R8, who's been, Lords, arrayed as a party. Lords, the facts have not been projected, Lords, correctly. Lords,
yeah, we will see that.
Yes, I'll just, Lords, stick to facts. I will not say anything more. Lords, R8 is the person, Lords, who filed a public interest litigation in 2022. Lords, what is projected before your lordships is, Lords, as if that it is a dispute between the church and, Lords, the temple. Lords, it is not. It is at my instance, Lords, that this honorable court, the division bench, ordered that as far as this scheduled property, which is considered to be a pathway, Lords, the extracts and the revenue records. Your lordship always goes with the revenue records, Lords. The Adanga.
No. Sorry, we go only by the findings of the High Court.
Yes, my lords, true.
Revenue records are Mr. Sricharan Rangarajan, I will tell you a very fundamental principle of civil law,
Yes,
which every lawyer is supposed to know,
yes.
that revenue record is only a record maintained by these people, people,
I understood. My lords.
who can't understand neither Tamil nor English, to collect revenue. Not only for the government, for themselves also, in the guise of correcting it now and then. So please don't rely upon the revenue records.
No, I won't, my lords. I'm sorry.
Yes.
I'll rephrase my sentence.
Now please keep quiet for some time.
I just wanted to point out on facts alone, my lords. Nothing, just to assist the court. It's just.
Are you suggesting that this judgment of Justice Raman in 277 of 93 does not relate to this property?
Lords, I will not say so. Lords, I will only say this. Lords,
If
I
you
will
don't say so, keep quiet.
Lords, I will only rephrase it and say it. Only 2 minutes of your lordships, my lords, kindly. I won't say, my lords, anything which is not there in the record. My lords, it is not the RDO's order is not happily worded, my lords. I cannot defend it when the learned AAG is there. I'm not talking.
Please
about
don't
that.
defend it.
My lords, as far as, my lords, the second appeal is concerned, my lords, where the dispute was between, my lords, the temple and the church, my lords, and that particular paragraph, my lords, what your lordship saw, it was a suit for declaration and permanent injunction. And the learned judge, my lord, says that if at all, when it comes to title, it is only the defendants, that is the temple, which could have better title. My lords, that's all para 100 says. My lords, what has happened here is, my lords, the division bench, after recording all these, my lords, judgments and, my lords, these cases which have transpired between the church and temple, my lords, record that as far as this pathway is concerned, which is also included in the subject survey. My lords, they say that there is no definite finding with respect to that. Therefore, they give an order to the RDO. Please inquire as to whether this is a pathway. And based on, my lords, the fact
So the
that
same, whatever the RDO has done was done by the division bench also. Pathetic. How can the division bench in a writ petition decide against a decision by a civil court in a second appeal? I don't think a division bench is superior to a second appellate judge.
Yes, definitely.
I
I will only take your lordship's, my lords, attention, my lords, for a moment, my lords, to the division bench's order itself, which your lordship will get at page 219.
Which itself is beyond its jurisdiction.
Lords, I will not, my lords, say beyond what is there in the order, because they have considered and recorded. Lords,
Yeah,
all
it is
that-
very easy for you to say.
Lords, I'm only stating, my lords, all that is recorded, my lords, and not that, my lords, they've given a definite finding.
What is the basis? What is the basis of that recording? Did they record evidence?
No, my lords, they did not decide on title either, my lords. I will not canvass that.
Then,
My lords, for a moment, my lords, because of the fact that government was not, my lords, your lordship saw in the second appeal the array of parties. The government were not arrayed as parties at all. At para number 4, my lords, at page 223, my lords, your lordship will see, my lords, this particular suit, my lords, transpiring into, my lords, the second appeal, and that it was in favor of the 9th respondent is all recorded. And thereafter, my lords, at page 224, para 5. Because the dispute relates today in respect of erecting of a compound wall, my lords, in the survey number to the 328 of 328/14. My lords, to that extent, my lords, at para 5, my lords, they have recorded that portion. My lords, at para 6, your lordship will see, my lords, this is the crucial part. In the two writ petitions referred, your lordship has that one. 224 paras 5 and 6. May I read that, my lords?
was there any appeal against WP 24320 of 22?
24320.
Para 5, 224, para 5.
No, my lords, I don't think so. I don't think so.
Then, when there is a direction of a single judge of this court allowing the construction of compound wall, how can in another writ petition the division bench change it?
There was no appeal. To my
Yes,
knowledge,
you-
subject to correction.
Saravanan, you are a party to this?
Yes, at para number 5,
Yes,
The writ petition will be
you
applied.
file a review of this judgment and bring it up.
one,
Please. please file a review of this judgment of the division bench and bring it up.
Much
We will remove that obstacle. Then we will see.
but in
When
fact,
there is an order by a single judge in a writ petition permitting construction of a compound wall, in the absence of an appeal against that order, how can another division bench say, no, relook into it? What is happening? This is not an appellate jurisdiction. PIL jurisdiction is not an appellate jurisdiction. I'm sorry.
Yes.
We are bound by some law. Yes, Saran, you seek review of this judgment.
yes,
Yes. Whatever interim order that was there will continue post on 27th. In the
be
meantime,
granted. Interim order may be granted, Millard, in the meeting.
yes, there will be what is the interim order you want?
The interim stay of the operations of impugned order passed.
There will be interim stay of the operation of the order impugned in the writ petition until further orders. You seek review of this judgment of the division bench.
Much of it.
The presence may be required.
Huh?
Presence of the RDO.
Whose presence? What am I to do with this man? What he will do? He will only nod. Huh. It is stated that the RDO who passed the impugned order is on maternity leave and the incumbent RDO is present. His presence is dispensed with for future hearings. Yes.